What is a trustee? A trustee is a designated individual that administers properties for a third party. They are a designated individual or group of individuals that holds and administers properties or assets for the benefit of a third party. They have fiduciary duties, legal authority, and responsibility to manage assets held in trust and handle the day-to-day financial matters on settlers' behalf. They are appointed by a settlor or by the court if the settlor failed to do so. The trustee is either appointed by the settlor or the court if the trustee failed to appoint someone, or if the appointed trustee fails. The trustee must voluntarily accept their position. Once accepted, the trustee cannot resign without the consent of all the beneficiaries or the court. Why are trustees important? They are entrusted with the holding and management of properties for the beneficiaries. They carry out the wishes of the settlor in accordance to the trust. As was mentioned earlier, trustees are designated individuals that are entrusted with the holding and administration of possession, land, or both for the beneficiaries if they exist in accordance to the wishes of the settlor. Depending on the circumstances, a trustee may be appointed for a wide variety of purposes, such as in the case of bankruptcy, for a charity, for a trust fund, to enforce and distribute assets according to the wishes of the deceased amongst the beneficiaries. What are the duties of trustees? Since the trustee holds legal title to the trust property, they owe fiduciary duties to the beneficiaries who hold equitable land. The trustee must distribute the property in accordance to the settlor's instruction and desires, with their primary jobs including the administration and distribution of the assets. A trustee is personally liable for a breach of their fiduciary duties. The trustee fiduciary duties include a duty of loyalty. The duty of loyalty requires that the trustee administers the trust solely in the interest of the beneficiary. A duty of prudence. The duty of prudence requires that the trustee is held to an objective standard of care in managing the trust property. Subsidiary duties. Subsidiary rules include the duty of impartiality, the duty not to intertwine trust property with the trustee's own personal property, and the duty to inform and account to the beneficiaries. The trustees will always have duties, or the trust will become passive and legal title will pass to the beneficiaries. If there are multiple trustees, they carry a dual accountability for their own actions, inactions, and decisions, as well as those of their co-trustees. Due to the fact that a trustee's role in a trust is to be guardian of purpose, they are obligated to making sure that all decisions put the needs of the beneficiaries first rather than their own. They safeguard the settlor's assets such as the property and business. Who qualifies as trustee? A trustee could be anyone. They could be a settlor's friend, lawyer, or family member. A beneficiary could even be a trustee provided that there are more than one beneficiaries. If not, then the trust would be void. However, the people who would be appointed the position of a trustee must be considered within the legal capacity to be a trustee. Therefore, anyone accepting the position of a trustee must be aware of its significant responsibilities. In a law, trustee must be capable of holding property, must be able to deal with the properties it required of them, be honest and not put their interest above the beneficiaries, know and understand the trustee document and responsibilities. The trustee must be able to manage the assets and distribute them to the beneficiaries, and they must be able to close the trust as determined by the trust laid out by the settlor.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Umar Farouk bin Rohaizat, DIL 201040. So today I'm going to present about the definition or the meaning of appointment, removal, and retirement. And I'm presenting this because my fellow classmates, my fellow group members are presenting about the appointment, retirement, and removal of a trustee. But before going deep into the topic itself, we have to remember, we have to acknowledge the meaning, the true meaning, why it exists, and what's the meaning behind the word of appointment, removal, and retirement. So I did some research, right? For the word of appointment, based on a legal dictionary, is the act of a person authorized by will or other instrument to direct how trust property shall be disposed of. Appointment is a person ke depan sangat. Is the act of a person authorized by a will or other instrument. It means that, example, the person is me. I am authorized by will or authorized by other instrument, meaning authorized by a meeting, let's say, from the board of directors if you're in a company, to appoint you, meaning to appoint me, and then they are the other instrument. They have the power to appoint someone. So the appointment must be made in such manner as to come within the spirit of power. Let's say the board of directors again. The board of directors have powers to elect, to appoint people. So an appointment is the act of the board of directors, for example, appoint someone. So although at law the rule only requires that some element, however, small shall be given to each person when the power is to appoint, and among several persons, the rule in equity differs and requires a real and substantial portion to each, and a mere nominal element one is deemed illusory to fraudulent. Okay, moving to removal. The meaning and the definition of the word removal. So as we all know, removal, its core word is remove. So when we talking about removal, we have to know in our head that something or someone has been removed, or something wants to remove, or someone wants to remove something, because it's called removal. And dia punya core word, the roots of the word is remove. And in the aspect of law, in the aspect of the economy, in the aspect of the working sector, removal can also mean transfer. The transfer of a person or a thing from one place to another. So when you remove, this company remove one person, the person move to another company. But removal, the process of removal raise serious questions concerning integrity. For example, a board of directors remove me. It shows their integrity. Why am I here in the first place if they are going to remove me? Something like that. It's called the act of federalism. So it's the relationship of one group or one person and the authority, saying the board of directors lah. So the removal procedure itself emphasize a very, very complicated step and also controversial processes. Okay, the meaning of retirement. Okay, the meaning of retirement. Retirement, we can say it's resignation, ataupun in Melayu, in bahasa Melayu, it's bersara lah. So retirement and resignation is quite the same, but it's not the same. You see, retirement is the act of someone quit his or her job, as well as resignation. But resignation, when the person quit, he have the ability or the choice to go and work to a new sector, to go and work to other places. But retirement means to quit your job, then no more working, didn't go to any more places to work in the same sector, different sector. Retirement is like the end, resignation, and no more working. So that's how resignation and retirement, that's the meaning of retirement. It's quite the same as resignation, but it differs a bit. Okay.
Hi, Assalamualaikum. My name is Mazia Fatima binti Sajahan. My matric number is DIL 202021. Today, I'm going to present about appointment of trustee. Appointment of trustee is the general rule is that anyone capable of holding property in law could also be made a trustee. However, a minor cannot be appointed as a trustee. It can't hold a legal estate. An infant may become a resulting or constructive trustee of personality. Ray Vinogradov, a child of 4 years, was ready to hold property on trust. In case of Puo Chiu Har v. Amanah Raya Berhad, the court is under no duty or obligation to work out the reason for the deceased appointment of the defendant because the trustee of her estate. A person may declare himself or herself as a trustee. A trust instrument may specify someone to appoint the trustees. An individual could even be a trustee by implication of law or by operation of law. Where the trust instrument or the desire makes no provision for the appointment of trustees, the court will make the specific appointment exception stated within the case of Ray Lysak if it's the essence of the trust that trustee is selected by settler and no one shall act as trustee. If trustee won't undertake the trust, then it will fail. Next one, I'm going to talk about ways of appointment of trustee. The first one is express provision. Section 14, subsection 1 provides the appointment of new trustee. A new trustee may be appointed in place of one who is, the first one is dead, the second one is remains out of Malaysian more than 12 months, desires to be discharged out of trust, unfit to act, which is mental illness, incapable of acting, and the last one is minor. Example of case law, Ray Walker, any brief written will break period of 12 months. As Mr. Summers had written, albeit for a week, he had not been absent for a continuous period of 1 year, the power to replace him had not arisen. Next one, Ray Lemon's trust. The wife in this case become incapable of acting as a trustee due to old age and consequent infirmity. She was physically unable to sign a document appointing a new trustee. The court held that as she was incapable of acting and as she could not appoint a replacement trustee, it was expedient for the court to do so in her place. Section 40 subsection 1 provides that power to appoint may be exercised by person nominated for the purpose of appointing a new trustee, or if no such person is able to willing to act, then by the surviving trustee or his personal representative. And the last one, if this person refuses to act, then beneficiaries may act if all of them are sui juris and all fully entitled to trust property. The next one, I want to explain about appointment by court. Section 45, subsection 1A, court has power to appoint new trustee to substitute or add trustee whenever it is expedient to appoint new trustee and found inexpedient, difficult, or impracticable to do so without assistance of court. Section 41, subsection 1B, without prejudice to power under section 41, subsection 1A, court may make an order to appoint a new trustee if the trustee is imprisoned, mentally disordered, unsound mind, bankrupt, corporation under liquidation, or has been dissolved. Okay, example of case law. The next subtopic that I'm going to explain is how many trustees. Based on section 39, subsection 1, in the case of settlements and dispositions on trust of property, whether movable or immovable, made or coming into operation on or after the material date, the number of trustees shall not in any case exceed 4, and where more than 4 persons are named as such trustees, the 4 first named who are able and willing to act shall alone be the trustees, and the another person named shall not be trustees unless appointed on the occurrence of a vacancy, and the number of the trustees shall not be increased beyond 4. Section 39, subsection 2, the restriction hereby imposed on the number of trustees do not apply in the case of property vested in trustees for charitable, religious, or public purposes. That's all from me. Thank you.
Assalamualaikum. My name is Amy Selina and my metric number is DIL 202013. So we continue with retirement of the trustee. The meaning of the trustee is discharge from responsibility and giving further the duty to person under the trust, and also the trustee cannot retire in the face of dispute between the beneficiaries and let them settle the difference between them. Besides, the retirement of the trustee has 3 portions, which is the express provision, statutory provision, and the order of the court. The express provision, where the trust provide clearly for the resignations of the trustee according to section 40(1) of the Trustee Act 1949 regarding power of appointing new or additional trustee, where this section enables the trustee to retire if he is being replaced by another trustee. Thus, there is several conditions where the trustee is allowed to retire without make a new appointment subject. By following the condition, a means of the trust corporation will remain as his retirement. His core trustee and such person empowers to appoint a new trust consent to his retirement. And last, his declaration to retire must be in writing. Thus, condition has been writing in the section 43 bracket 1 of the Trustee Act 1949. Then in the court order where the trustee may order the trustee of retired under section 45 when appointing a new trustee in place of a trustee who has been sentenced as imprisonment or is no longer qualified to be a trustee, and also the court has a power under jurisdiction is allow a trustee to retire. In addition, in situation where the trustee is dead, this trusteeship will automatically terminate on death. This can be referred to section 23 bracket 1 of the Trustee Act 1946, where the trustee is imposed on two or more trustees, which is the same way, may be performed by their survivor for the time being. Lastly, if there is sole trustee or surviving trustee, then the trustee property will be handed over to his personal representative. Okay, that's all for me, and I will pass to the next presenter.
Assalamualaikum and hi, my name is Akila Batrisha. My matric number is DIL 202003. Today I will be presenting about the removal of trustee. As we all know, all the trustee can be appointed. They also can be removed. There are some reasons why the trustee should be removed. Here are some reasons why the removal of the trustee should be made. So firstly is failure to comply with trust term, neglecting, mismanaging trust assets, misconduct and self-dealing, hostility toward the beneficiaries, breach of trust, trustee failure to act, trustee being under undue influence, hostility between trustee and beneficiaries. All of these terms is the terms of the removal of the trustee. To remove the trustee is not easy. There are two ways to remove the trustee. So firstly is by the trust document. Some of the trust document already grant the ability to dismiss the trustee to the trust beneficiary or the named person. So if this matter happen, the beneficiary have a power to remove the trustee. But however, if the trust document didn't mention about the ability to dismiss the trustee, so these cases we can proceed it to the court. Court has jurisdiction to remove the trustee based on section 63 of the Trustee Act 1949 revised 1978. That's all from me. Thank you.
Okay, Assalamualaikum warahmatullahi wabarakatuh. Now, before I proceed with my part, I would like to introduce myself. My name is Syed Abu Bakar Al-Hadi bin Syed Faisal, and my matric number is DIL 201075. Now, to conclude what we have learned in this group assignment, any matters pertaining to the removal, appointment, or retirement of trustees should be referred to in the Trustee Act 1949. As an example, when a removal of a trustee occurs, Section 63 of the Trustee Act 1949 has provided about the power to relieve trustee from personal liability, which stated that if it appears to the court that a trustee, whether appointed by the court or otherwise, is or may be personally liable for any breach of trust, whether the transaction alleged to be a breach of trust occurred before or after the commencement of this act, but has acted honestly and reasonably and ought fairly to be excused for the breach of a trust and for omitting to obtain the directions of the court in the matter in which he committed such breach, then the court may relieve him either wholly or partly from personal liability for the same. Furthermore, the Trustee Act can also be applied when appointing a trustee, as stated in sections 41 to 45 of the Act. Last but not least, This act also comes hand in hand when a trustee retires. According to Section 40, subsection 1 of the Trustee Act 1949, regarding power of appointing or additional trustees, where this section enables a trustee to retire if he is being replaced by another trustee. From this, we may conclude that the Trustee Act 1949, revised 1978, has laid down the foundation for us to utilize in case we face the situation of appointing, removing, or retirement of a trustee. Now, basically, the conclusion is a bit of everything that has been stated previously above in this assignment. It's basically a summary of what we have learned so far. So that is all for my part. Thank you. Assalamualaikum warahmatullahi wabarakatuh.